Again, you're going to have to look at your local rules. In San Francisco, there's a specific provision in Rule 7 indicating that whatever you say in that form can't be used against you at a later date. This is for the court's assistance in making that determination that we talked about earlier, whether or not the case should be ordered mandatorily to arbitration or not. So you give them the information that you can and send a copy to the other side so he knows what's coming up.
Now, as we've mentioned on several occasions during this evening, there are going to be times when there's going to be some difficulty for the court to indicate what the value of the case is and so forth. So you ought to be pretty sure to be as definitive as possible on these forms, to give as much information to the judge who's going to make the decision. And you're going to have to check your local rules very carefully, because in San Francisco, the judge can determine that case is not arbitratable, and you won't have to go through a conference with the judge. He'll merely send that case out for a trial-setting conference. It's going to save you one step along the way. But in the event that you have to appear at this conference, in some communities, some areas, the judge will then determine whether this is a case that could be settled, and he may assign this out to a settlement conference, and that will be held at a later time, some maybe 6 weeks after that, and then at that particular settlement conference it'll be treated as most settlement conferences are treated, I imagine. Bill, what would you do in preparation for that situation?
Well, to back up just a little bit, Norm, and to answer your question at the same time, as soon as I get this form to fill out, as I'm filling out the first page of the form to say whether or not I think the case should be ordered to arbitration or not, I'm also going to review where I am in my discovery and get the rest of it done as soon as I can. Then Norm and I will end up going before the arbitration conference judge in San Francisco, assuming that they can't tell from the form absolutely clearly whether or not it should go to arbitration. We'll discuss it with him briefly, because he's only got a limited amount of time to look at each one of these cases. As Norm mentioned, if he thinks that it's the type of case that has some potential for settlement, he may order it to a settlement conference that may be that month or maybe 6 weeks down the line. Norm and I will then appear at the settlement conference, and in the order that the judge makes sending us to that settlement conference, he may also order us to do certain additional things, to exchange offers of settlement if that's the case, or perhaps it may be a case where Norm and I, for some reason or other, haven't talked about this case. We haven't even, there hasn't even been a demand made, so the court might order that demand to be made. When we get to the settlement conference, it will be one of these special settlement conferences that Norm talked about earlier that they're holding in San Francisco. We might be before a judge, we might be before a panel of attorneys. If the case isn't settled, if we can't reach some sort of an agreement at that settlement conference and wrap it up, then we'll be sent back up to the arbitration conference judge's chambers or courtroom, where we will, under the present procedures, be handed a list with the names of the arbitrators on it and asked if we can agree on an arbitrator.
Bill, there's one alternative that you didn't mention, and we haven't seen a very great deal of lately, but that is maybe they're going to send you down to municipal court if you've really got a case that's only worth $3,500. That has begun to occur, and what the future holds for that device is yet to be seen. Remember, about 80% of these cases, the personal injury case, the typical case we're talking about, Norm, are going to settle out for less than $15,000. So it shouldn't be any great act of intelligence for someone to determine that the case is within the jurisdiction of the municipal court and send you back down there.
Well, we've gotten back to the point, Norm, where we're now standing in the arbitration conference judge's courtroom, and it's become apparent that we're not going to settle the case, and it's at this point that we are now presented with a list of 3 names and some suggestion that perhaps we might want to use a retired judge as an arbitrator or what have you.
Well, touching on the system, depending, of course, which court you're going to be involved in, most courts we'll have panels of 3. And it's always, you always want to get the arbitrator that most likely deals in the kind of work that you do. So then the struggle goes on to determine, well, is he a plaintiff's arbitrator, is he a defense arbitrator, and so forth. Of course, what we're going to find out is because of the volume of cases going to arbitration, there are going to be many new arbitrators that no one knows anything at all about. So hopefully the arbitrators that are going to be on the panels will have some experience. And I know that in some communities, such as San Francisco, where a concerted effort has been made